Uh, what is your name?
Hector Garza?
Hector.
Yes, sir.
All right. Whose motion or what's going on?
Your Honor, I represent the plaintiffs in this case, and it's our motion to compel oral deposition of the respondent, Mr. Liu. And if I may, Judge, this case actually is quite, the case itself is not old. The incident arose out of a car accident that happened back in
Out of
April,
a what?
out of a car accident that happened back in April of 2018. Suit was eventually filed in April of 2020. Upon respondent filing his answer, we immediately filed a discovery request on May the 5th of 2020. Responses came just a little late and were tendered on June the 9th, 2020. Immediately after that, right at towards the end of June, we moved to set oral depositions of Mr. Liu. And we've attached attachments to our motion, Judge, which if the court feels necessary, we can put those up on the screen for your honor to see. But at that point, we communicated with Ms. Montes' office in scheduling the deposition. And there was an agreement to set the deposition in July 24th, 2020. So deposition notices were sent out and along we go. Or excuse me, there was communication, I take that back, and we couldn't necessarily come to a date. Ms. Montes wanted it several months out. We wanted it a little bit more expeditious than that. So when we set it, she immediately moved and filed a motion to quash to stop our deposition. So on or about July 15th, we spoke again, or we emailed really. We haven't really spoken about the case or about any of this. And there was communication that went back and forth about trying to set the deposition since there was objection to it because she wasn't available. So this time we picked a date, and that date was to be August 4th, 2020. So at that point, we sent out notices of deposition for August 4th. On that date, Ms. Montes immediately filed a motion to quash that deposition once again because she didn't want to make her client available for an oral depo and insisted that it be taken by video as opposed to in person. We ultimately came up with some.
What is the reason for the motion to quash the August 4th date?
The motion to quash back then or now?
The August 4th date.
Oh, the August 4th day, she quashed that because I wanted to take it in person and she wanted to do it by video.
And that was mainly because of the pandemic.
That was her position.
Correct.
Now, at that point, Judge, I will state that shortly after that, there was some conflicts that arose for both Ms. Montes and myself. And so we ended up agreeing to reset that oral deposition to another day.
In person or
No, so on August 18th, 2020.
you guys are,
Yeah.
I'm sorry. Was the agreement then for a in-person depo or video?
No, at that point, Judge, we agreed to go ahead and move the depot and we were going to do it by video. So we emailed, our staff really emailed back and forth one more time. And we agreed to the date of October 12th, 2020. And so we sent out amended notice to take oral deposition by video. And that went out and was set up. There was some conflict at that point. Ms. Montes' staff then attempted to attack our choice of October 12th And we emailed them back telling them, no, this is the date you offered. This is the date we went with. How is this going to become an issue? And it was basically left alone. Now, at that point, on October 9th, days before the deposition, Ms. Montes then emailed our office and canceled the deposition because she was not going to, it was her or her client that was not going to be available. And so now we're at a point where her email specifically states our client just notified us that he will not be available for deposition on the 12th, which was a little disturbing because it was going to be by video. So it's not like he had to travel anywhere. But now we had yet another cancellation of the depot. So we started communicating in efforts of trying to reschedule it again. After several emails, the deposition on November 17th, there was finally an agreement to December 29th, 2020. Now, at this point, Judge, if I may, I will start sharing some documents because I think it becomes very relevant to track some of the, in my opinion, some of the conduct that took place. So at this point, we agreed, we started asking for dates. And this is attachment H is an email from Ms. Montes' staff to our staff saying that the December 16th was no longer available and that they had the following dates. Keep in mind that these dates, they fill up fast and what have you. So the next attachment, J, then has my staff advising her staff that let's do the 29th, as the 29th was one of the days that was proposed. Next, attachment K has her staff then telling us, if you'll note right here, that our client is confirmed for deposition on January the 29th, 2021 at 10 a.m. And if I go back to H, you'll note that their date was December 29th is what they had proposed. Now, my staff then emailed her staff back saying you did mean December 29th, as that was the date that was agreed upon, not January 29th. Her staff then texts back in capital letters, yes, December 29th. So we're now agreed to and set for December 29th. Now, I will state, Judge, at this point that we did not send out yet another, a fourth amended motion or amended notice of intent to take oral deposition. But we were all in agreement. Again, this is our fourth shot at trying to get this done. Days before, or the day before the deposition, we verified with the organization of Tim Kendall and Associates, KTA, about making sure that we were set up to do the deposition. At that point, Ms. Montes started emailing or her staff started emailing that they needed an interpreter and that they were not going to be making the respondent available for deposition because he needed an interpreter. Now, I had emailed Ms. Montes in the not too distant past that it was our position that Mr. Liu spoke perfectly good English. His son actually contacted my office shortly, I'd say maybe 2 or 3 weeks after the accident, and he spoke perfectly good English. The police report states that Mr. Liu spoke to the police and was able to very effectively communicate his position to what happened in the accident. We've learned that Mr. Liu is actually a physician. He's actually should be Dr. Liu. And the man works in the US. I believe he may work out of the country as well, but he has an active driver's license and he's a professional. So we know that he speaks perfectly good English. However, Ms. Montes feels that he needs a interpreter. And at about 1:10 this afternoon, Ms. Montez, as has been very typical with her handling of this case, sends me a response citing a battery of code that I've managed to get through um, that is really disturbing. We have been trying to get this deposition set and going, but Ms. Montes has done nothing more than delay and obstruct this deposition from carrying on. So much so that in her motion, she cites several codes. If we go backwards from her response, at one point she cites Civil Practice and Remedies Code, Chapter 21, which talks about requirements for an interpreter for deaf people. Doesn't go into anything else other than deaf people. Ms. Montes is trying to deflect and confuse the situation. She cites code or the government code, chapter 57, where it does speak to court shall appoint an interpreter if the court feels that such is necessary. The code then goes on to establish what requirements may or may not be needed depending on the population. We obviously are in a county that has more than 50,000 people. So the court can appoint somebody that is not certified if the language necessary in this proceeding is something other than Spanish. And the court makes a finding that there is no interpreters within 75 miles of Bexar County. Now, I don't know if there's a Mandarin interpreter in our area because I haven't researched it, because our position is that Mr. Liu speaks perfectly good English. However, if Ms. Montes has pushed this, so I imagine she's going to know and have better disposition as to whether there is a certified Mandarin interpreter within 75 miles of us. Further, she goes on to speak about Chapter 183 of the Texas Rules of Civil Procedure. 183 merely speaks to the court can elect to appoint an interpreter and who that's going to be taxed to. Further, she cites 199, which 199 speaks to depositions upon oral examination. And I've read through that entire code and I read through it again before we came in here. And perhaps Ms. Montes can point us to the spot where it talks about interpreters and how they're supposed to be designated or carried out. At this point, Judge, we have been more than patient. We have taken 4 shots at trying to set this deposition. We've had to deal with 2 suspensions based on Ms. Montez's filing of motions to quash. Now we have this extensive response and we have a straight up cancellation on the 3rd attempt by Ms. Montez on her client. Judge, we just need to set this deposition. We need to compel Mr. Liu to present himself or have Ms. Montez present Mr. Liu for the deposition. If the court feels that, or our position is if Mr. Liu feels that he needs an interpreter, then he needs to provide his interpreter. If the court feels that one needs to be appointed, then so be it. At this point, we don't believe that it should be our responsibility to have to pay for that interpreter because, again, our position is that he speaks perfectly good English. But if the court sees fit that it should be our expense, then so be it. At this point, Judge, we're just seeking an order to have this deposition carry out, to obligate Mr. Liu to present himself for this deposition because it has taken way too long. And all we're doing is delaying this process even further unnecessarily. And equally, Judge, we'd be asking the court to grant us attorney's fees in this case because this is ridiculous. We should not have to go through this much trouble and deal with all these cancellations and motions to quash by Ms. Montez just to carry out one deposition. We've been expeditious in trying to deal with this. We set our original motion for deposition just weeks after discussing responses were tendered, and we've been expeditious in trying to reset each of the follow-up depositions, which we've always been subject to Ms. Montez's schedule. But we're through with that, Judge. Now, all of that needs to end, and we just need to set a date and compel Mr. Liu to present himself. And we'd ask that the court grant us attorney's fees for having to deal with this. This should not be this difficult.
Anything further, Mr. Garza?
Not at this time, no.
Ms. Montanez?
Yes, good afternoon, Judge. Thank you for having me. If I could, I would like to present my response and as well make the court aware that defendant, in addition to filing a response to this motion to compel, has filed counter motions for protection and as well motion for appointment of qualified interpreter that are currently pending before the court and really should be heard at the same time as this plaintiff's motion to compel, because they're all germane to the same.
Objection, Your Honor. Ms. Montes, objection means you stop. Your Honor, I'm going to object to the mentioning and the request of any prior motions or other motions. This response that I just noticed, I hadn't looked at the title, but this response that Ms. Montes filed does include motion for protection and some other motions. These motions were not properly set. We were not given proper notice to prepare for these motions. As such, they should not be considered. Ms. Montes' untimeliness of this should not in any way impede our request, as once again, we have done everything that we're supposed to by the law. Ms. Montes is untimely and seeks to do nothing further, nothing more than delay. So we would object to any argument of any motions that were not properly filed and request the court to obligate Ms. Montes to stick to simply her response to our motion to compare oral deposition.
Is it Montanez?
It's Montanez, Judge. And I do not appreciate the interruption here when I'm trying to present my response and to assist the court in understanding what the actual issues are.
Ms. Montanez?
Yes, Judge.
Ms. Montanez?
Yes, Judge.
Any attorney has a right to object, even if you're in the middle of an explanation. I don't understand your objection. It borders on being a sidebar. Now, have you timely filed the motions that you're wanting to address right now?
These motions are timely filed in the sense that there is no deadline to file these motions. And my request is that the court hear plaintiff's motion and defendant's motions at the same time, because they are all germane to the same issue and best presented together. And if Mr. Garza does not want them all heard today, I would request that we set these related motions for hearing at the same time.
When did you file those motions, ma'am?
Your Honor, the motions as well as the response were filed today in response to plaintiff's motion, which was filed just a few days ago.
When was, Mr. Garza, when did you file your motions? What date?
Judge, ours was filed on January 6, 2021, file stamped 11:47 in the morning, and they were accepted the following day at 3:25. So actually 6 days ago.
And the notice that you gave?
Was 6 days ago.
Same day?
Same day, Your Honor.
All right. Ms. Montanez, your request to hear your motions today is not timely. I'm denying that at this time. Now, that means simply you will address the motions and the information Mr. Garza has presented.
Yes, Judge, and I'd be happy to do so.
Thank you.
But I'd also like to make a request on the record that these motions of defendant be set for hearing because they are in fact germane to the issue of this deposition and very relevant to what's going on here in this case. This defendant's response in opposition to plaintiff's motion to compel. There's some important information, I believe, that has not yet been presented to the court, and that is that defendant, Mr. Liu, is a Mandarin speaker and he's not proficient in the English language. I'm not sure what information Mr. Garza has or what it's based on or where he got it, but it's simply not the case. We notified Mr. Garza of defendant's language barrier and a need for a Mandarin interpreter for the deposition that plaintiffs requested no later than October 9th. And in connection with discussing scheduling party depositions for December 29th of 2020, we again reminded and notified Mr. Garza that defendant has a language barrier and needs a Mandarin interpreter if he is to be deposed. Again, deposed at plaintiff's request. And this took place on November 18th of 2020. Again, we're talking about possible deposition date of December 29th. A few days later, December 2nd, Mr. Garza sends an email to us refusing to provide the interpreter necessary for plaintiffs to depose defendant. And specifically, it stated, Mr. Garza wanted to clarify if you will be providing the Chinese Mandarin translator for your client, Mr. Liu, if he requires such for the deposition. Mr. Garza wanted to make it understood we will not be providing the translator for Mr. Liu. The next day, on December 3rd, I responded. And in my response, I stated, no, we do not provide interpreters for depositions requested or noticed by other parties. At no point after this did plaintiffs ever end up serving a notice of intent to depose Mr. Liu on December 29th of 2020. Yet on January 6th, they filed a motion seeking to compel a deposition that they in fact did not notice. I understand that there's a history of attempting to set this deposition, and I'm more than happy to go into the facts of the other prior attempts and the motions to quash that defendant had to file because Mr. Garza was trying to make him appear in person despite Texas Supreme Court orders prohibiting in-person appearances during that time. But for the sake of brevity, I'd like to just focus on this December 29th date. The fact of the matter is plaintiffs have not adduced and cannot adduce any evidence that they gave proper notice according to the Texas Rules of Civil Procedure 199 and 215 of the purported deposition, or that defendant failed to appear for that deposition because it was never noticed. And therefore plaintiff's motion must be denied. What this really boils down to is that plaintiffs don't want to pay the necessary costs that will have to be incurred to depose defendant. And they're trying to force defendant to pay for his own deposition that they're requesting. Judge, I understand that, for example, if this was trial and we were affirmatively calling our client and presenting him as a witness to the jury, I agree the expense for that interpreter would be on defendant. But in this instance, at the request of plaintiffs to take defendant's deposition, it is plaintiff's responsibility to incur the expenses related to that deposition. One of the expenses being the need for an interpreter that our client is entitled to under state and federal law. And that's what my motion for interpreter goes into in more detail, but which will not be presented today pursuant to your earlier ruling. Nevertheless, defendant is in agreement to give his deposition, but he is not in agreement to pay for plaintiffs to take his deposition. Plaintiffs want the deposition. Plaintiffs need to pay the costs that are going to be incurred in order to take that deposition. And to continue pushing this issue and going to the extent of filing a motion to compel when Mr. Garza is well aware that this simply hinges on my client needing and being entitled to an interpreter in order to be able to be deposed. I do not understand. Plaintiff's motion should be denied, but I'd like to state on the record, defendant is in agreement to give his deposition. He simply asked that plaintiffs provide the necessary interpreter in order for him to be able to do so.
Brief
All right.
response.
Excuse me. Did you have something, Mr. Garza?
Judge, I just wanted to present a brief response, if I may.
I'm listening.
I think the first thing I really want to clear up, Judge, is we are not expecting for the respondent to pay for this deposition. I hired KTA, had KTA present. We've already incurred a bill for December 29th and his lack of presence at that time that I have to pay for. And we're prepared to pay for this again. We're not asking, at this point, we're not asking for him to pay for it. So let's make sure we're understood. We're okay with paying for the deposition. As far as the interpreter goes, that we feel that it is upon respondent to provide his own interpreter. Just as Ms. Montana stated, at court, she knows that it is her responsibility to provide the interpreter. Well, the last time I checked, a deposition is no different than a court. We have a court record that is taken, and we have a court record that could be read in court or question the defendant with it in court. They're equivalent. So the respondent should be held responsible to pay for his own interpreter. A couple of short things. The Texas Supreme Court is not prohibited in person. They strongly suggested that there would not be in person unless courts can make or take proper accommodations to protect court staff and everybody else. I have already attended in-person hearings, both in Maverick County as well as in Bastrop County. So there is in-person happening despite Ms. Monta's incorrect representation of the Texas Supreme Court's directives. And as I stated earlier, Judge, I had already stated, as Ms. Monta said, that we did not send the actual fourth amended notice for deposition for the December date. Again, it was an oversight on our part, but we had set this so many times that it was that oversight. But at this point, Judge, we just need to get this done. And respondent should pay for his own interpreter. That's it.
I have some questions. Ms. Montanus,
Yes, Judge.
how long has Mr. Liu lived in the United States of America? Do you
Judge,
know
I
as
cannot
as
answer
an
that
officer of the
question
court?
off the cuff.
I take it you don't hire a interpreter when you meet with your client. I'm not asking what you say or don't say, but is my impression correct? Or as an officer of the court, you tell me no, you do use an interpreter?
In order to communicate with our client directly, yes, we have to have interpretation.
And you don't know how long he's lived in the United States?
I do not know the answer to that.
Do you know
but
whether,
I don't think that that's
do you know
germane
whether
to
he
the issue
conducts
of his English
a business as a
proficiency.
medical doctor?
Excuse me, Judge, I couldn't hear you.
I'm sorry. Ms. Montanus, is your client a practicing physician?
I'm not sure the answer to that question,
You're not?
one way or the other.
I find that intriguing, man. I've only practiced 47 years and I've never known a client that does, an attorney that doesn't know how his or her client is employed or how long he or she has lived in this country. I caution you that you're an officer of the court. Is he a physician or an MD?
Your Honor, I would need time to verify that. I do not know offhand.
Anything else, Mr. Garza?
The only other thing I would have, Judge, is if Your Honor would consider the attorney's fees, I could put on proof as to that.
Ms. Montanus, anything else from you?
Yes, Judge. Mr. Garza has called into question whether or not my client is entitled to an interpreter and argues that he is not, or that it's his responsibility. And those arguments specifically open the door to defendant's motion for appointment of an interpreter. And without being able to present that information today to the court is an unfair position for defendant to be in, because defendant in fact does require an interpreter and is entitled under state and federal law to a court-appointed interpreter, which he is seeking in one of his motions filed today. So again, I'm hamstrung to be able to fully address Mr. Garza's arguments without going into the substance of those motions and the supporting authority.
Well, anything else, ma'am?
Yes, again, I'd like to say that defendant is in agreement to be deposed. He is not in agreement to incur the cost of the interpreter plaintiffs require in order to depose him. Plaintiffs have not presented any authority that would show that defendant is responsible for paying for costs incurred with regard to depositions that they have noticed or requested, and that he is entitled to a court-appointed interpreter for those deposition proceedings. And if we have an understanding and an agreement that plaintiffs are willing to incur the expense of the interpreter, although I do not believe it is defendant's responsibility to find or provide one, I am more than willing and happy to work with Mr. Garza to try to identify a Mandarin interpreter who can assist us with moving forward with this deposition. I also would like to see these depositions taken. I have no intent or desire to delay them. My only intent and desire is to protect my client's best interests, and presenting him for a deposition without an interpreter would be the opposite of doing that. It would be putting him in harm's way. And so that being said, again, defendant agrees to give his deposition and will even agree to try to find an interpreter for that deposition, conditioned on plaintiffs' understanding and agreement that they will incur the expenses related to that deposition, including the interpreter.
I have some more questions for you, Ms. Montanus. The documentation that Mr. Garza presented appears that both offices, and not necessarily you personally or him personally, but that both offices agreed in writing to the 29th as a date for the deposition. Am I correct, or am I misinformed or misunderstanding?
I would hate to suggest that the court is misunderstanding, but yes, indeed, I do believe that is the case. The dates that were tossed around for December 29th were then followed by the correspondence and disputes regarding the need for the interpreter and who would provide it. At best, a tentative date and a tentative agreement for Mr. Garza's office to issue a notice for that deposition. These emails are not, they don't amount to a Rule 11 agreement on discovery. They were never on file with the court in advance, and they don't constitute a proper notice of deposition under the Texas Rules of Civil Procedure 199 and 215. Really, there's absent a Rule 11 agreement on file with the court or a proper notice of deposition pursuant to the Texas Rules of Civil Procedure. No, there was no real agreement. And that's further supported by the fact that after tossing around dates, then the dispute arose as to the interpreter who was going to bear that burden. And it was my understanding that when Mr. Garza's office informed us we will not be providing the interpreter, that they meant we're not going to find one or pay for one. So unfortunately, it seems that there has been some misunderstanding all the way around, but the fact is this deposition was never properly noticed and there was no actual agreement.
All right.
It would be enforceable.
I'm going to order that your defendant is compelled to appear for deposition. Before we close this hearing, I want to know what specific date my order will include. I will order that there be a Mandarin interpreter. As a side note, I have had one appear in my criminal court for a Chinese defendant. So there are some here in San Antonio. The cost of the interpreter are going to be taxed as costs. The prevailing side will not pay. The losing side will pay the cost of the interpreter. Further, I might have an investigation done to determine, since you could not provide it, the length of time Dr. Liu or Mr. Liu has lived in this country, if he is in fact a practicing physician. And if he is, then I'm going to revisit the issue of who pays for the interpreter. Is that clear to both sides?
Understood.
Mr. Garza?
Yes, sir. I guess the only question I would have, Judge, is the organization KTA, they're obviously, with the interpreter. The interpreter is going to want to get paid when we set up the depot. I guess just in being able to get this done and get this done expeditiously, we'll assume the cost and then we can revisit upon confirming Mr. Liu's English abilities and how long he's been in the country and everything else that we learn. If you learn it before us, great. If we learn it before you, then we can come back and revisit that.
All right. Then what's the date we're going to have?
Right now I have January 29th wide open.
Ms. Montanus?
I have the morning of January 26th and all day January 27th.
Let's do the 27th in the afternoon, Judge. The 26th, I have court settings in the morning.
You have the 27th available, Mr. Garza?
27th, 2 o'clock.
2 o'clock. Ms. Montanus, you said you were available on the 27th. Is that correct?
That's correct, Judge.
Then you will have your client available on the 27th at 2 p.m. in accordance with the notice that Mr. Garza will give. and obviously a specific site. Let's talk about that. What will be the site, Mr. Garza?
Your Honor, we'll be doing it by Zoom, Judge. We'll,
Right, okay.
once
So
again,
I would just want that as part of the order, that it's clear that it's not gonna be in person, it's gonna be on Zoom. What else do we need to tie down so there's no question about it?
with a Mandarin interpreter.
That is already part of it. That's part of what I've ordered a moment ago. Yes.
we've already expressed it, that we'll absorb the cost. And then if we reach conclusions about Mr. Liu, we'll follow a motion to reconsider. And that's to accept.
All right. Then anything else, Mr. Garza?
Nothing further, Judge. I'll prepare an order and circulate along with our new notice for oral depot.
Tell me what the attorney's fees would be as far as the amount that you're demanding.
Your Honor, to this point, I had asked for $2,800, which would be $350 an hour for 8 hours. I bill at $350 an hour. I've practiced in Texas really for 15 years. I've done civil litigation my entire career. I practiced throughout the entire state of Texas. So I feel that $350 for someone of my experience is fair and reasonable in Bexar County for that matter. So we would have been requesting 8 hours total time, dealing with just the deposition issue alone.
On what basis do you say 8 hours, sir, for this specific motion?
Well, not for the specific motion, Your Honor. I was relating it to the specific issue of trying to get the deposition taken care of. As far as specifically to this motion, I would have to say that would probably be maybe 2.5 hours from the extensive motion that I prepared with the extensive exhibits, and then preparing for the motion, having to research Miss Montana's response that she sent 30 minutes or 25 minutes prior to the hearing. And then the 30 minutes or so we spent here actually probably be more like 2.5 hours. So it would be based at 2.5 hours at $350 an hour.
Give me a final number.
Oh my goodness. Be $875, Judge.
All right. The court will find that the court costs are $875. I will forego, or I will hold in abeyance the determination of whether you're granted attorney's fees or not. That'll depend upon the information that is learned either by the court, actually, that will be provided by the attorneys. I expect you both to provide me that information. How long has Mr. Liu been here? Is he in fact Dr. Liu? Does he have a practice? For how long? I would like to also know where he's been educated, if he was educated outside this country or whether he was educated in this country. That would have a significant bearing on my questions.
Yes, sir.
All right. You might glean that in your deposition. That's up to you how you provide me the information.
I had already thought about doing that as we were speaking, Your Honor.
All right. Anything else, Ms. Montanus? Let me just say to
Well,
both of
Judge, it may be premature, but defendant would object to any award of attorney's fees on plaintiff's motion because plaintiff's motion was premature and that they never served a proper notice, and attorney's fees and sanctions on a motion to compel are contingent on proper notice having been provided. Without proper notice, attorney's fees are not proper.
you may be correct, but I'll be looking at the issue of whether the court was treated with the respect it deserves by way of the officers of the court providing information that they have or don't have. We'll find that out.
Yes, Judge, defendant will be happy to provide all the information that's been requested.
Thank you, ma'am. All right, then, that'll conclude this